Okay, guys, we're going to get right into this video because I've got to wake up early tomorrow to go work with the homeless. As you know, every Wednesday I work with the homeless, so I'm not going to be there on phone calls if you call in on Wednesday. Now, let's get right to the point of this video. These are 5 questions that Social Security disability judges and SSI disability judges will ask and already know the answer to, or at least part of the answer to it, in a hearing for benefits. So please remember to like, please remember to subscribe. Don't be stingy with that like button. Let's get right to it. Here's the things when it comes to these. You've got to understand that sometimes these judges will ask questions and they're looking to see essentially if you're going to lie on record. They're looking to see if you are going to, basically have the memory as to what actually occurred. They're looking to see how much training you've had. So all of these things are this brewing option of where you stand on answering a question that they already know the answer to. Okay. Ultimately, you should be aware of these questions ahead of time so that you know to collect the answers before the judge asks you them. Now, some of you will complain in the chat and comment section that it's not those judges, it's not their place, right, to play these games with you. Play the disability ethical card in the comment section. That's fine, but let's not BS each other here about what's actually going on, because it's not going to ultimately stop the judges from asking you these questions, knowing that there's a hidden answer, knowing the answer ahead of time, and then you basically stepping into the mud. We want you to know ahead of time what to watch out for, and these are those 5 questions for your disability hearing. Now, here we go. Like and subscribe. Number 1, what is your highest level of education? Once again, what is your highest level of education? Now, people learn that the more educated you are, the harder it is to be found disabled. So they're going to say that they have less education. People also don't remember where their academia usually ended. Sometimes people forget about their thereafter certifications, security clearances, or specialized allowances/permits. So this is a question where the judge goes to the SSA 3368 and basically looks to what the claimant filled out as to their highest level of education. Okay. Now, keep in mind, with this said, they also look to the 3369 to see what type of jobs they put down against the detailed earnings query as well provided by the IRS. And some jobs require additional training and education and certification to be able to do them, right? If you're going to be operating a heavy machine and that heavy machine requires additional certification, that's education. All right, so the bottom line here is a result of all of these things. It's a good example of a question that the judge already knows the answer to when they're asking the question, or they have a pretty clear image of what the answer will likely be. And you've got to think, what am I missing here? What is the judge getting at here? All right, next question. Let's go to it. When was the last time that you used illegal narcotics? And here's the problem with this. Let's assume your attorney has read through every page and mapped it out. Let's assume they didn't miss something in the thousands and thousands of pages. Let's also assume that the claimant knows around about when the last time that they used was. Remember, they're not going to be perfectly on with this one because they were using narcotics. When you're on narcotics, your brain doesn't remember things in a precise manner. It's not a perfect Swiss watch and it's clicking in just a beautiful way. It's kind of like that piece of crap, Russian car that normally you wouldn't get into, but it was free. So let's, we'll do it. All right. Here's what nipped me in the butt with this very, very harsh situation. The judge introduced evidence into the case documents folder right before the hearing, which I wasn't able to read that morning. So we proceeded anyways with the hearing. I validate the record. We get to this question, and the new medical record has a more recent date on it for use and abuse. So the claimant states one date. The judge knows a different date. The judge tells me which exhibit and page to go look at because there's a more recent date. I go to the F folder, which has the medical records, to review it during the hearing. Sure as shit, there it is. Now, remember, we are running questions live, right? Then and there. The claimant's there, the judge is there, I'm there. It's happening. It is live theater. It is going on. And here's the problem. It's a disability hearing. So if I ask for a moment to review this information with my client off record, The judge, I know, is going to tell me that we will need to set another date for another hearing because of time limitations and the massive backlog. Okay, so a bad choice for me since this claimant barely woke up for this hearing to begin with. So we continue. We keep doing the hearing. And post-hearing, I find out that the medical facility just copy and pasted test results with the exact same numbers from before onto the new visit date. Cool. I notify the judge, but remember, during the hearing, I'm sitting there looking less pretty because my client can't remember when they really stopped using drugs. Because, as you guessed it, they were using mind-altering drugs. Anyways, happy story. They were approved with an amended negotiated alleged onset date. But be careful with this one. Okay, remember to like and subscribe, guys. Click the all button. Don't be stingy with those likes. Number, what is it, 3? I think we're on 3. What are we on? We're on 1, 2. We're on 3. All right. Have you been taking your medication as prescribed? This can be a naughty question. So here's the thing. Sometimes you guys think you are being smooth, like a creamy milkshake filled with lemons. And you don't realize that your meds are something that either directly shows up as a test number at a medical facility or directly affects a bodily function that shows up as a test number. So if you don't like the medicine you want to, take, the doctor may know that you are playing a game, and when you say you're taking it, you're not actually taking it. Now, look, the mental impairment claimants, they know they can get away with playing this game, right? They can go ahead and have medication prescribed to them. They cannot take it, and boom, for the most part, with most medications, it's not going to show up unless it's a particular couple of medications that clearly show up. The diabetes people and the cardiovascular people, they can't play this game even a little bit. So the point is, the doctor will write into the record that the claimant is not following their prescriptions as required by their medical prescription. Okay. Know that when when you get this question from the judge, know that it's with purpose. Like the judge might have something up their sleeve, and you may want to think long and hard and also quickly because it's happening, it's live, it's going on, about what is in your medical record. And this is why people who represent themselves are so fragile in a hearing. They're so capable of being destroyed. They go in there not knowing what the record has, and then a law school graduate, right? Highly trained analysis machine will outsmart them easily with collected evidence that the claimant hasn't read because they're a federal judge. I've always thought that was weird, that someone's ego would be so big that they would go into a hearing to battle a Juris Doctorate federal judge, and they gamble their future on the idea that they're so disabled because their friend who has had benefits forever isn't as bad as them. It's an interesting study on human confidence and intelligence. I say that because if people ask themselves how sure they were and why they felt so strongly about something, they would usually use emotion instead of logic as their main answering point. And that's not good. That's a bad deal. Next question. Remember to like and subscribe. Don't be stingy. Here we go. When was the last time you worked? Okay. All right. So sometimes claimants, they whoops on this one. All right. First thing the judge is going to do, and I see some really cool people in here. Old school truck driver. I see you, Robert Wolf. I see you there. Casper, I see your comment there. Nice. Very cool. I see some other people that I see here. Very cool. All right. So here's the deal. When was the last time you worked? First thing the judge is going to do is they're going to go to the IRS earnings. They're going to look and see exactly in the detailed earnings query, what were the jobs that are basically listed out there. They're going to look at when you weren't working, when there's basically gaps in employment, all that stuff. Okay. Medical records may show injury reports with why you got injured. And some of you, to be fair, will tell your doctor you were working on this side job to do this side thing. And then all of a sudden that's in there, and it's the most recent work you've had. Judges know that people work under the table when seeking disability benefits because they need the money to pay the rent. Let President Biden hire 1 million new IRS agents. Let him do it. And they will never catch all the disabled who are working under the table. Just ain't going to happen. Bottom line, it's funny is they could actually fix that by allowing them to just work and earn more, not have it be so abusive towards them, other than having the unsuccessful work rule. They could fix that, but that's another video. Bottom line, when the judge asks you about additional work after the last reported job on the IRS reports, they already know the answer to that question. They're just waiting to see if you're going to tell them the answer. Last question. When was the last time you were out of the country? Very, very spicy question. Remember that time you got a medical shot before traveling? Remember that time you were telling your doctor you needed extra medication because you were going overseas for a month? Remember that time you wanted more pain meds, herpes meds? That was one of them. One of my claimants got caught on that one, etc., etc. The judges can see that in the record. They know to ask you when the last time was. And then they say, well, what about May of 2023? And when I hear that, I know that my claimant has just firmly taken their foot and placed it into the deepest mud pile that they could find. And then they've got you. Because you don't know if you said something to your doctor or if they just have auxiliary evidence that points to a likely vacation, then they've got you by the coconuts. Because the coconuts, right? Good joke. Palm trees. There you go. Because no matter what, you've got to start singing a different song than you originally answered. Just be aware of this because they likely already know part of or the entire answer. Now, guys, if you enjoyed this video, please remember to like and subscribe. Use the like button. Don't be afraid of it. It's simple. You use the finger. Most of you have one. You just go ahead and, basically utilize it to click the button. Now, with that said, don't be stingy on those likes. Also, the thing I love waking up to, and it is right now 1:02 a.m. before I have to wake up at 7. Please remember, when I wake up to those 5 stars, you don't have to leave a 5-star, but if you go to Google Disability Resolution Florida or Disability Resolution Law Firm, you can leave a review. I love waking up to those. Finally, if you need a disability attorney, you know who to call. I will catch you guys later. Please have a wonderful night, and we will go from there. Thanks so much, and I'll catch you later. All right. Bye-bye. Bye-bye.